this question covers May-June 2015, paper 4, set 3, right? And it specifically covers the chapter of private nuisance. Right, let's start off by reading the question first. The key issue when deciding liability in the tort of private nuisance is the reasonableness of the defendant's activities. Critically evaluate whether the current rules achieve a satisfactory balance between the rights and interests of neighbors. Support your views with decided case law. As you all know, the question actually covers nuisance, and why is that? Firstly, is because of the keyword here, tort of private nuisance. Okay, and what is the question asking us to do? Right, is to critically evaluate whether the current rules achieve a satisfactory balance, okay, between rights and interests of neighbors. Okay, and of course at the same time we should also support it with case law. So let's get to the answer itself. Right, now we will start to go through the essay itself, and as I go through I will pick out some of the things, okay, which is either good or bad, and will give my comments about it. And other than that, also we'll see whether or not there's any way for us to actually improve on this essay. Although generally, okay, because I've actually gone through it once already, I would say that it is generally quite well done, right? Okay, so the tort of nuisance set out to protect the right to use and enjoy land without interference from others. The tort of private nuisance arises from the fact that whenever we live or play, we have neighbors, and the way that we behave on our land may affect them when using theirs, and vice versa. All right, good. This is a more or less good introduction, also definition of tort of nuisance first. The statement above regarding the key issue when deciding liability in a tort of private nuisance is the reasonableness of the defendant's activities. It's not true because the claimant must also prove the other two elements, which is indirect interference with the enjoyment of land and interference which can cause damage to the claimant. Okay. Whether the current rule achieves a satisfactory balance between the rights and interests of neighbors will be critically evaluated in my answer below. Okay, firstly, regarding this statement here, I would say that it isn't very good to start off by saying something like this here. All right, here, right, where it says that it is not true from the beginning itself. Right, I mean, it's not too good for you to give away your conclusion within the introduction itself, but it's not really a big issue, right? The next thing that I want to highlight is actually with regards to this part here, which is the thesis statement, which seems fine, okay, where basically the student is saying that whether the current rules, okay, achieve the satisfactory balance between the rights and interests of neighbors will be critically evaluated in my answer below. Usually the thesis statement is more or less a rehash of the question itself, or at least the focus of the question, right? So that you know that you are not actually writing out of the topic or digressing, right? Okay, let us move on to the first body paragraph. To support the justification that the key issue in deciding the tort of private nuisance is not the issue of reasonableness, there are three elements that the claimant must prove in order to bring an action under nuisance. Okay, right, because like I say, this issue here regarding not true, okay, is again, right, not very good to mention in the beginning itself, but since the student did already mention it already, it's fine, doesn't matter, and it's better that now the student actually did re-emphasize it here. All right, okay. Right, so firstly, there must be an indirect interference, which is usually the result of a continuing state of affairs, okay, other than a one-off incident, right, good. Indirect interference can be caused by physical invasion, okay, under this case here, Davy, intangible invasion, okay, noise, under Christie and Davy as well, or smell, or in the form of emotional distress, okay, right. For example, right, so it's good that the student actually did highlight a few first, and then now wanting to emphasize more, okay, on a particular case, okay, that the students actually highlighted, and that is Thompson, Schwab versus Kostaki. The court held that running the premise for prostitution is an otherwise respectable in an otherwise respectable residential street is considered a nuisance. The following element is that damage such as emotional distress or physical damage must have caused to the claimant's land. Okay, no issue here. Relevant case will be in St. Helens smelting tipping, where the fumes from the upper smelting works damage trees and shrubs growing on the claimant's land. With regards to the third element, right? So the third element already, the issue of unreasonableness. If the interference goes beyond the normal bounds of acceptable behavior, it will be considered as unreasonable. Okay, no issue here. In deciding whether the conduct is reasonable, the court will take into account the following factors. Okay, right. So this is, I feel that it should actually be broken into another paragraph already, because this part here is actually something else already. Okay, right. I mean, it's at least, I mean, not to say something else, but it it should actually be, it can actually be something which stand alone already. Okay, firstly, whether interference with land is reasonable may depend on the locality. What is the nuisance in a quiet residential area may not be a nuisance in an industrial location. The relevant case will be in Helen Smelting versus Tipping, where the court held that the claimant were not expected to put up with the actual damage to their land resulting from the normal activities of the locality. Besides, the court will also consider whether there is malice or bad motive. Okay. So like in the next one, in Christie and Davy, the defendant next door deliberately tried to disturb both lessons and parties in the claimant. Right here, I think should emphasize a little bit more that the next case that you're talking about is regarding bad motive, by saying something like such as, okay, bad motive can, or malice can be illustrated with this case, something like that. Okay, thus the court held that malicious motive made the defendant's conduct unreasonable and a nuisance. The following factor concerning sensitivity. See, again, this whole thing, it should actually be another paragraph, right? Right. The traditional rule is that the defendant is not responsible for damage which occurs solely because the claimant or the claimant situation is abnormally sensitive. Okay, which can be seen in Robinson versus Gilbert. I should say here, the defendant was held not liable due to the extraordinary sensitivity of the material of the claimant's paper. Furthermore, the duration and timing will also play a significant role. For example, in Halsey versus Esso Petroleum, the noise caused by filling petrol tankers was reasonable and so not a nuisance at 10 a.m., but was a nuisance at 10 p.m. Okay. It is necessary for the claimant to prove all these three elements. They are all equally important, and the court will not be biased on any particular one of them. Okay. All right. I would say that this first part is basically, the whole the three elements here, okay, of private nuisance, right? But I feel that it's quite compressed here, right? So what the student can actually do is to actually separate the three elements. All right, so I feel that the three elements discussed here is a bit too compressed and can actually be separated into three different paragraphs so that it would seem clearer that you are discussing three separate things, right? Otherwise, okay, it's a bit confusing to me, at least, okay, right? But to the examiner may or may not be, right? But still, okay, because these three elements, they are pretty big. Okay, I mean, there's a lot to talk about. Okay, so it will be good to actually separate them into three separate paragraphs, so that also at the same time it can leave you a bit more space to discuss a little bit more, because I feel that you are like rushing through this thing. Okay, right? Right, but the information is fine. It's just that, like I say, right, it's, I mean, superficial purposes. Okay, right, it'd be good to actually just separate them. And other than that, okay, right, while you have separated them, okay, you might actually have enough, a bit more space, okay, to discuss a little bit more. Although it's not really necessary. Okay, if you just separate them into 3 paragraphs alone, I guess it should be fine. Okay. Right, now let's move on to the next paragraph. In assessing the truth that the current rules have failed to achieve the satisfactory balance between the rights and interests of neighbors, we will be looking into the defenses of statutory authority. In fact, okay, I've seen down there already, okay, the student actually did also talk about the prescription, as you can see here. Right, so it will be good, okay, because here you are actually trying to highlight both the rights and interests of neighbors already, okay, and so therefore the argument can be either way, right, and in which also later on, okay, right, I see that you already have the mind to discuss the other way already, okay, so it will be good to at least just mention here, okay, defenses such as statutory authority and prescription. And then only in this paragraph here, then you continue to actually emphasize and discuss on statutory authority only. Okay. And another thing that I want to highlight is the fact that, okay, that is good that the student actually did from here onwards address the question. And of course, the question is asking you to critically evaluate whether or not, okay, the rules to achieve a satisfactory balance between the rights and interests of neighbors. Okay, let's move on. The defense of statutory authority can be applied when a statute orders something to be done, and by doing it will inevitably create a nuisance. There will be no liability because the statute is treated as having authorized the nuisance. The relevant case, okay, fine here. The relevant case is Allen versus Gulf Oil Refining Limited. On the facts of the case, right, good that now you're actually referring to it. On the facts of the case, C. Claimant brought an action for the smell, noise, and vibration created by the oil refinery, which had construed by the defendant on their land. Construed? Okay, never mind. The defendant's action in constructing the oil refinery was authorized by an act of parliament, and hence the defendant was held to be not liable. Okay. Such defense is definitely unfair to the claimant in a sense that the Act of Parliament should not be given such an excessive power to the defendant. Wow, excessive power. Okay, I wouldn't say excessive power, but that is a nice way of putting it. Since it is undeniable that the claimant in this case do suffer a loss of enjoyment of land, why should their claim be refused? Okay, that's a good question there. This is an area where the law has failed to protect the claimant's right to use and enjoy land, and the defense seems to have worked to the advantage of the defendant. Hence, the balance between rights and interests in neighbors can be said to have failed to achieve already. Okay, but okay, because I can see that the next one you're actually talking about prescription already. There is actually some balance, okay, to be discussed here when you actually talk about statutory authority. Okay, because if you remember or if you look at your textbook there, okay, there's also the discussion about alternative statutory remedy or something like that, okay, whereby within the statute itself, okay, as much as it provides a defense for the defendant, okay, to actually avoid nuisance, right, but there is actually some way for the claimant to still claim compensation, but that claiming compensation is through the statute itself. Okay, right, so it'd be good to look that up. All right, so it will be good for you to actually look up this case here. Okay, Markic versus Thames Water Utilities 2004 on the alternative statutory remedies. Right, so it's, I mean, there's quite a lot that you can talk about. Okay, but it is good to actually include it there. Okay, that is if you actually have the time. Right, because after all, the question's focus is on, again, critically evaluate. right? Whether or not they achieve a satisfactory balance between rights and interests. So putting this case in and also this argument should actually be a very good thing. Okay. Right. Next one. However, the desired balance can be regarded to have been achieved for the following reasons. Firstly, okay, it is good that, okay, right, you actually discuss both, okay, and yes, okay, you talk about both kind of defenses, okay, work differently, okay, it's fine. Next one. Firstly, the defense of prescription is available to the defendant where the defendant will be held to have acquired the right to commit a nuisance with the requirement that it must have been actionable for at least 20 years and the claimant was aware of this during the relevant period. This defense has helped to achieve the balance as it acts fairly towards both the claimant and the defendant. If we put ourselves in the defendant's shoes, okay, 19 years is sufficiently long for the claimant to bring an action. All right, good explanation here. If the claimant can accept the nuisance for the past 19 years, there seems to be no reason why she cannot do so 19 years later. Okay, right. Meanwhile, this defense also protects the interests of the claimant by imposing the limitation that the claimant must be aware of the nuisance. Right, so at least, okay, right, there's a little bit of balance discussion here already regarding rights and interests. Okay, for instance, in the case of Sturgis and Brickman, although the noise had been going on for more than 20 years, it did not become a nuisance until the claimant's consulting room was built. Okay, the fact that it may have been a nuisance of people occupying other property is not sufficient to create perspective right. I think it's prospective right. I think, okay, right. I think you have there's a typo here. Thus, the defense of the prescription can be regarded to have contributed to the desired balance. Besides, the court has also provided remedies such as abatement, self-help, which allows the claimant to take steps to end the nuisance. All right, okay, good. Injunctions and damages to claimant. For example, in the case of Delaware, mentions Westminster City Council, the court held that the claimant is entitled to both the remedies of abatement and as well as damages. So I guess it's a good thing that the student is relating this case and also this kind of this kind of remedies, okay, to the previous case or the previous issue. The grant of injunction can be seen in Canaway versus Thompson, where the court held that despite the public interest in the activity, C was entitled to an injunction limiting the times at which the activity could be performed. In short, the availability of the defense of prescription and injunction has helped to protect the rights and interests of the neighbors. All right, good. But if you ask me, okay, again, because I'm looking at this whole paragraph here, the fact that you've discussed this case here, Sturgis and Brickman, okay, is actually in contrast with the situation under prescription, okay, the defense of prescription, okay, there's actually a balanced discussion about rights and interests already, okay, right? So just like in this the previous paragraph, right, like I told you about, okay, this part where you're talking about statutory authority, here even with this one case or two cases here, okay, you can actually discuss it both ways already. So what I'm trying to say is that for both of these defenses, right, in which you use as a discussion point or evaluative discussion point to discuss the fact that, you know, whether or not there's any balance, okay, in rights and interests, okay, right, it'll be good to actually discuss both ways for both defenses. As both defenses, you can also discuss both ways, okay, so that you make it seem a bit more critically evaluative. Okay, I'm not saying that what you've done here is wrong, okay, right, but okay, it's something to think about, okay, especially for, although this one here, okay, regarding the market situation, right, um okay, regarding the statutory authority, okay, it would be good, okay, to actually mention Markik's case, okay, the alternative thing, All right, okay, so I hope that you understand what I'm talking about. Okay, it's just like this one here where there's actually the alternative, okay, where basically Sturgis and Brickman is sort of going against the defense of prescription. Okay, because here of course firstly you actually did talk about what it is first, and then after that give a contrasting case, okay, that sort of does goes against this thing. Okay, right? Right, and in conclusion, reasonableness is just one of the factors that the court will consider when deciding liability in the tort of private nuisance. Okay, it can be said that the defense of prescription and remedies have been leaning towards the achievement of satisfactory balance between the rights and interests of neighbors, but the defense of statutory authority is in need of some improvement so that the balance can be achieved successfully. Okay, that is fine. Right, now let us look at the marking scheme. Yeah. Right, let us just go through the marking scheme very quickly. So firstly, it says the thought of private nuisance arises from the fact that wherever we live or work or play, we have neighbors, and the way that we behave on our land may affect them using theirs, and also vice versa. I think the student actually did mention this, okay, all right, from the beginning there itself. Okay, next one. Candidates should explain the key elements of thought of nuisance, such as indirect interference, reasonableness of action, and the extent to which the interests are balanced by taking into account the complaints of sensitivity, locality, duration of the alleged thought, and the extent to which the thought of sort of damage needs to be caused. All right, which the student did mention all these things definitely. Okay, and this one is, I believe, okay, right, it's here. Yeah, the first paragraph which I say just now, okay, should actually be separated into at least 3 paragraphs. Okay, all right, so it's all there, so it's fine. And also with reference to case law, which is vital here, in which the student again did, okay, reference to vital case law when the student is actually talking about the 3 different elements, okay, or requirements under private nuisance. Okay. Okay, next one. Candidates should analyze the approach taken by the courts when dealing with the issue of reasonableness and examine relevant case law as part of this discussion. No issue there. Okay, right. The student did put it there. Candidates might also consider the extent to which available defenses such as prescription and consent and remedies such as damages, injunction, and abatement enable the aim of balance to be achieved. Yes, very good as well. Okay, right, because the student did mention about yes, here from this paragraph onwards, okay, all right, which is basically the evaluative component. And of course, okay, the evaluative component consists of discussing the defenses, and also the student did mention remedies as well, okay, in relation to the defense of prescription, okay, which is good. But then like it says here, okay, enable the aim of balance to be achieved, okay, then you should actually discuss both ways for both defenses, okay. But it will seem that only for here, okay, when you're actually talking about the defense of prescription, that there's actually a balance going on, okay, even though it's not very obvious, but it's there. But for this thing here, discussion of statutory authority seems pretty much one-sided only, because it would seem that in your mind itself, okay, you are actually thinking about, okay, discussing statutory authority as something being unfair, and then it doesn't balance the rights and interests of the people. Whereas this one here, when you're discussing about defenses, okay, right, you're discussing it in a way where there is a balance, okay, right. So yeah. Okay, then lastly here, candidates should address the question and form of conclusion as to whether the issue of reasonableness is the key issue in nuisance, or whether it is simply one of the factors taken into account. Okay, I believe that the student didn't really emphasize much on this thing here, okay, right? But generally, okay, because it's all I would say the discussion of reasonableness and also the balance of rights and interests are all actually jumbled up, especially in this paragraph and also this paragraph already. So I think it's generally fine, especially right in the conclusion itself, right? The student did try to highlight it again and also did try to emphasize on certain things in which was already discussed here, okay, in the evaluative part in this the last two paragraph. Again, all right, it will be good to actually separate it into two paragraphs, okay, otherwise it's like too jumbled up, okay. All right, generally, okay, it is fine. Okay, so let me just put a comment there first. All right, I would say that it is generally well done, but it will be good to separate some points into separate paragraphs so that it doesn't seem rushed or compressed. Okay, so this is just my opinion about it. Okay, because because we need to take into consideration the fact that for examination purposes, okay, you only have half an hour to do it. So usually it's not about making it seem very nice, but to make sure that all the points are there. Right, so the overall marks that I will give for this answer is 20 or 25, okay, possibly even above 20, okay, because it's very compact, it's all there, all right, and it's actually also addressing the question quite well, other than this part here, that's all, okay, all right, okay, so yeah, I guess that's about it.